Hello, everybody. My name is Dr. Mark Leiser. I'm an academic, author, and technology law consultant. I work at the Riga Graduate School of Law in Digidata Consulting. It's been a busy few weeks, to say the least. We've had a number of things happen all at once relating this concept of data and what it means to the European Union. I've written a series of Substack posts on my page, Lawboy, Lawbhoy. And in those posts, I've addressed the issues of what is personal data, the promise of the digital omnibus, the EDPB guidelines, DG Comp's approach to search data in light of Article 611 of the Digital Markets Act, the digital omnibus, I already said that, and everything else in between. But I think what I'm going to try and do in this lecture is bring it all together and talk about primarily what anonymization looks like after the single resolution board, or EDPS versus SRB, and what that did, the combination of the contextual approach to anonymization that comes in light of the EDPB proposed guidelines, and put it into some context for you in relation to the other thing that's happened in the last couple of weeks, which is DG Comp's suggested guidelines on search data and how that should be anonymized and what that looks like. So what I fear is that we have multiple forms of anonymization, and this lecture is going to try and tackle what that looks like. So I want to begin not with Google, the DMA or AI, but with SRB, Single Resolution Board. So following the resolution of Banco Popular, affected shareholders and creditors submitted comments to the Single Resolution Board. The SRB separated those comments from identifying information and sent a filtered set to Deloitte. Each comment carried a randomly generated code, but only the SRB possessed the information needed to reconnect that code to an individual. So the European Data Protection Supervisor viewed the material sent to Deloitte as personal data. And the resulting litigation produced a deceptively simple question. So when pseudonymized information moves from an organization that can identify people to a recipient that cannot, is it personal data for both? And how you answer this question has incredibly far-reaching implications, because the EDPS believed that all pseudonymized data is personal in every instance. And myself, many other people have disagreed with this interpretation, that it doesn't take into consideration recital 26. And so the question and how you answer this question matters far beyond the original dispute. It determines whether personal data is an intrinsic property of information, or what I say is a relational legal status, depending on the actor, the means of identification, and then the surrounding context. So if I don't have the legal means to re-identify, if I don't have any interest in re-identifying, if I don't have the key to re-identifying, should I be treated as holding personal data when I've received pseudonymous data from somebody that holds the key and can limit my ability to re-identify those people? So SRB doesn't make pseudonymized data anonymous, but it did change the question from could somebody identify to who, in this particular processing situation, can realistically identify. And that goes away from the privacy maximalist approach, I think, where every synonymous data is personal. And I think this is the point of departure. And it's really important to kind of put this into context. So how the court answered this contains two propositions that you really have to keep together. First, pseudonymized data need not be personal data in all cases and for every person. For Deloitte, the comments could cease to be personal if Deloitte could neither defeat the separation measures nor identify the authors by cross-checking the comments with other information. So this is the opening, really important that everybody understands this, is that identifiability post-SRB is contextual and recipient-relative. But the court also held that the SRB transparency obligation had to be assessed at the moment of collection and from the SRB's perspective. At that time, the SRB could identify the participants. And if you can identify the participants, pretty straightforward, that's personal data. So it couldn't escape its duty to inform them about downstream recipients merely because somebody else is receiving non-identifiable material. So that's the limit. SRB creates neither a universal exemption or a universal classification. Perspective depends partly on the legal obligation being applied. The source controller remains responsible for the personal data processing that produces the transformed output. The recipient may nevertheless receive information that is no longer personal from its perspective. That's the real kind of doctrinal movement here, but it leaves the operational question unanswered. What must organizations actually demonstrate before recipient-specific anonymity can be relied upon? And the EDPB Guidelines 02/2026 attempt to answer that question. And so the factual and legal account that is put forward by the EDPB in its guidelines follows the reasoning of the court's judgment in EDPS versus SRB. And that's really important. SRB gives us the principle. Identifiability can be relative to the relevant actor. The guidelines seem to translate that principle into two ways of assessing whether anonymization has worked. The simplified approach deliberately disregards differences between entities, who has access, what auxiliary information they possess, and what resources they can deploy. It asks a conservative question. Could re-identification work in theory? This isn't an alternative legal standard. It's a screening device, and it may keep data within the GDPR, even where the data would actually be anonymous for a particular recipient. The contextualized approach applies the legal analysis in full. We begin with the question at the center of my own work, anonymous for whom? We then map each relevant entity's role, access, auxiliary information, capabilities, and means reasonably likely to be used. A public release, a controlled research environment, an independent recipient, and a processor are therefore not interchangeable contexts. Both approaches use the same three outcome tests: no record isolation, no linkage, and no inference. No record isolation asks whether a unique combination of attributes isolates one's person's record. No linkage asks whether that record can be connected to information about the same person elsewhere. No inference asks whether data enables a specific and meaningful inference about an individual represented in the source data. That last qualification matters. Useful population level learning is not the same as individual level leakage. These criteria are warning lights, not a guillotine. Passing all three supplies a safe basis for concluding that the data is anonymous. Failing one triggers further analysis. Can someone actually distinguish and treat the person differently with sufficient accuracy, using means reasonably likely to be used from that entity's perspective? This is why my position is contextual anonymization, yes. Contractual anonymization, which I'll talk a little bit more later, no. Key separation, access controls, clean rooms, auditing and enforcing enforceable contracts can alter the context, but they cannot simply rename identifiable data. The discipline must remain anonymization first and utility second. That takes us to the next question. If anonymity does not require zero risk, when does the remaining likelihood of identification become insignificant in reality? This reflects both the EDPB Guidelines 02/2026 and the argument developed in my posts, Anonymization After SRB and Context is Not Unequal. The guidelines reject an absolute test. Identification need not be impossible. Its likelihood must be insignificant in reality for the relevant entity. I think this is important because almost any data set can be connected to a person if we imagine unlimited resources, future databases, and sufficiently determined adversaries. A legal test based on theoretical possibility would make anonymization practically unattainable. And the guidelines instead ask whether a relevant entity can distinguish a person within the applicable context using that test from recital 26 means reasonably likely to be used with sufficient confidence to treat that person differently. So uniqueness is relevant, but it's not necessarily decisive. A row may be unique without giving an actor any realistic way to connect it to a person. Conversely, an apparent or-day record may become identifying when combined with supplementary information. The difficulty is that the guidelines also identify a potentially expansive universe of relevant actors: rogue employees, unethical companies, journalists, intelligence agencies, cybercriminals. These actors may be relevant in a particular case, but a contextual test must not quietly become a worst case test. The correct discipline, I think, is actually foreseeability. Which actors access? What incentive would they have? What auxiliary information could they realistically obtain? What technical route would allow them attribution? How much time, cost, and labor would it require? And a concrete chain of identification, therefore, belongs in the assessment. An adversary imagined without evidence does not. Otherwise, insignificant reality becomes zero risk under another name. Once identification is understood as a likelihood, safeguards become part of the factual assessment. The next question is what different safeguards actually do. So what should they actually do? Well, first, I think we need to distinguish between data controls and context controls. Data controls change the information of the output itself. Suppression techniques, generalization, randomization, aggregation, and restrictions on query results. Context controls change the environment, access restrictions, confidentiality, monitoring, contracts, login, sanctions, and organizational separation. Both can reduce likelihood, but they behave differently. A data control remains embedded in the information if the dataset is copied or accessed without authorization. A context control depends on the environment continuing to operate. Once data leave that environment, the contract or the access policy may no longer protect against technical linkage. That doesn't make necessarily contracts irrelevant, and they are part of the today's way of doing business. But an effective legal prohibition can affect whether a particular means is reasonably likely to be used. A contractual prohibition can also contribute where it is reliable, verifiable, and enforceable, particularly when supported by monitoring, audit rights, and meaningful sanctions. But a promise not to re-identify is not itself anonymization. So the defensive position is cumulative. The data must first resist identification to an appropriate degree. Governance controls then reinforce that resistance and constrain the recipient. That is why controlled disclosure can be assessed differently from publication. But a controlled environment cannot simply relabel personal data as anonymous. With the relevant means and the controls identified, the guardians next ask what the proposed use actually produces. So the no inference criterion actually contains one of the guidelines' most important distinctions. An anonymous dataset may still support useful learning about a population. There's a bank loan example in the guidelines which demonstrates this point. Historical data may reveal that a combination of characteristics correlates with default. A bank can apply that general knowledge to a future applicant who has never been in the source dataset. The resulting decision may involve personal data about the applicant, but that doesn't automatically mean that the historical dataset remained personal. Generalized learning is not the same as leakage about someone represented in the source material. The position changes when the output preserves a source-specific connection. A persistent pseudonym, device identifier, or fingerprint may allow an actor to follow the same person and treat them differently without knowing their civil name. A model may permit memorization, extraction, or membership inference about someone in its training data. Synthetic data may reproduce rare combinations associated with an individual. The legal question is therefore not whether the system performs analytics. Almost all useful systems do. The question is whether the processing produces a specific and meaningful inference about an individual represented in the underlying data, or merely knowledge about a wider population. That distinction creates general space for statistical research. Aggregate analysis and sub-model development does not transform internal synonymized analytics into non-personal processing, and the answer can change depending on who receives the data. And the guidelines accept recipient relative status, but they draw a hard line around processor relationships. A source controller may retain the key or the source records. For that controller, the material remains personal. A genuinely independent recipient may receive transformed information, determine its own processes and means, and lack any realistic route back to individuals. From that recipient's perspective, the information may be anonymous. But a processor is different. When an organization processes information on behalf of a controller, the controller's perspective follows the processing. If the controller can identify the people concerned, the processor must treat the information as personal, even if it's technically unable to identify anyone itself. The EDPB describes this as an anti-evasion rule. A controller cannot outsource its way out of the GDPR. So I think that answer is legally coherent, but it's practically significant. Many privacy-enhancing infrastructures, cloud analytics, clean rooms, trusted research environments, de-identification services, and model evaluation providers operate through processor relationships. Their technical blindness remains relevant to security, proportionality, breach risk, and contractual design. But it doesn't necessarily remove them from the GDPR. Role analysis must therefore come before identifiability analysis. Who determines the purpose? Who chooses the essential data? Who designs the architecture? Who can alter the processing? That brings the discussion here from doctrine to enforcement. That brings the abstract role question down to earth. In the CNIL IQVIA case, pharmacy data moved through an extraction module through successive hashing by trusted parties and into an IQVIA warehouse containing longitudinal records. It is tempting to begin at the end of that chain and ask only whether IQVIA could recover a patient's name. But role analysis comes first. IQVIA specified the data flow, determined what information would be extracted, and designed the chain through which the data traveled. It was not simply handed a dataset designed by somebody else. The CNIL's essential point was that legal responsibility follows actual control. It does not disappear merely because several intermediaries or technical transformations have been placed between the source systems and the final warehouse. That does not mean that every vendor designing a component automatically becomes a controller. It means that the vendor's actual decisions must be examined before its legal role is accepted. The CNIL also concluded that the warehouse data remains anonymous. The records were longitudinal and connected through persistent codes. Rare medical events and auxiliary information could potentially support record isolation and linkage. These two inquiries must nevertheless remain distinct. Controllership does not, by itself, prove that the data are identifiable, just as repeated hashing does not prove that they are anonymous. We must first establish whose purposes, means, and capabilities count, and then apply no record isolation, no linkage, and no inference from that entity's perspective. The decision, therefore, does not invalidate conventional de-identification practice. It requires an honest account of who designed the architecture, who controls the linkage structure, and what the resulting data permit. It takes us to the next problem. If one unusual record remains vulnerable, does that make the entire data set personal? The guidelines state that risk must be insignificant for the individuals represented in the data. They also recognize that identifying a single person can demonstrate a technique's success. The protective intuition is understandable. A controller cannot call a dataset anonymous while knowingly leaving a rare or vulnerable person exposed. But two questions must be separated. Does a single successful attack reveal a shared weakness in the dataset, or does it expose only an isolated separable component? If the vulnerable records can genuinely be separated, suppressed, or handled as personal data, a proportionate response may preserve an anonymous remainder. But where personal and non-personal elements are inextricably linked, separability may be impossible. This is where the Google Article 611 DMA case begins to lurk in the background. Search queries may contain information about the person searching and about somebody merely mentioned in the query. Those two populations may be intertwined in the same free text record. The competitively valuable detail is often the same detail that creates the identification risk. The Google case is therefore not the source of the doctrine. It's the stress test waiting for the doctrine. Before applying it, however, The UK comparison helps us redefine the difference between uniqueness and identifiability. The ICO says that distinguishing a unique row in a table is not sufficient by itself to make the corresponding person identifiable. The question is whether the associated information, together with realistic supplementary information, allows a person to be distinguished with sufficient certainty. The ICO is strict where internal information is concerned. If a controller retains the means of reconnecting the records, the information remains personal in its hands. Processors and joint controllers do not receive an independent anonymity perspective. For external recipients, however, the ICO is more willing to account for defined recipient groups, actual expertise, controlled disclosure, and legal or contractual restrictions. That creates a different evidential instinct. The EDPB gives us entity mapping, chains of means, the three technical criteria, and repeated life cycle assessment. The ICO gives us a motivated intruder and a more implementation-oriented inquiry. Their thresholds overlap, sufficiently remote, and insignificant in reality, point in a similar direction. But the practical weight assigned to contextual controls may differ. The two systems are therefore closer in law than they first appear. Both arrive at a contextual destination, but the ICO presents an implementation method while the EDPB presents a legal test accompanied by a more elaborate threat model. Comparison matters, however, only if it changes what organizations actually do. With the doctrine, the case studies, and the regulatory comparison now in place, we can answer the practical question: what margin of use has genuinely opened? The answer to this question is more precise than either nothing has changed or anonymization has become easy. A real but bounded margin has opened. The clearest space is population level analytics and robust aggregate outputs. These users produce knowledge about groups without preserving a source-specific connection to an individual. Research by a genuinely independent recipient may also fall within this category, where that recipient lacks any realistic means of isolation, linkage, or inference. Even record-level material may be anonymous in a particular recipient's hands, but only where there is no usable route back to the people represented in it. The fact that the data remain detailed or analytically valuable does not by itself decide their legal status. The conditional middle is larger. Controlled recipient environments may change the relevant identification context. Synthetic data and model artifacts may be usable, but only after appropriate testing for memorization, extraction, and individual level leakage. Data space reuse depends on strict boundaries governing access, onward disclosure, and purpose. Synonymized internal analysis also appears in this middle category, but it ordinarily remains personal data processing for the controller. The guidelines may make that analysis easier to justify and govern, but they do not rename it anonymous. The closed category is equally important. The controller cannot launder personal data through a processor. A contract cannot manufacture anonymity. A clean room does not change legal status merely because it's called clean. And stable identifiers that permit personalized treatment continue to connect processing to individuals. That's where the Article 611 DMA Google problem lurks in the background. Competition law may require useful data sharing, but it cannot decree anonymity. The architecture, recipient capabilities, auxiliary information, and potential for individual treatment still determine the GDPR question. The practical margin is therefore real, but narrow and engineered. It follows capability and use, not labels. It's also expensive to prove, which brings us to market structure. And that's because an evidential burden is also an economic burden. A defensible contextual assessment may require an organization to map roles, data flows, and auxiliary information, identify realistic actors, apply the 3 outcome test, test synthetic or model outputs, document technical or contractual controls, and establish when a reassessment will occur. These are largely fixed specialist costs. A large incumbent can employ in-house lawyers and engineers, develop a repeatable internal method, and spread the cost across numerous products and projects. Regulatory uncertainty is easier for it to absorb. An SME, a research team, public interest organization may have to purchase the same expertise for a single project. Indeed, it may possess fewer auxiliary datasets and weaker identification capabilities than the incumbent, making anonymity more plausible from its perspective, while simultaneously lacking the resources required to prove that conclusion. The simplified approach, in theory, offers a cheaper answer by disregarding those contextual differences, but it knowingly accepts false negatives. Data that could properly be treated as anonymous remain classified as personal. For smaller actors, that can mean over-compliance, abandoning a research project, or leaving potentially useful data untouched. This is where the innovation mandate argument that I make as well becomes concrete. A formal, neutral, legal test can still redistribute market opportunity through the cost and uncertainty of implementation. The answer is not a lower privacy standards, it's reusable assurance, recognized testing methods, predictable evidential treatment, controlled environment pathways, and proportionate documentation. The consultation must therefore make contextual anonymization usable and foreseeable rather than merely available in theory. 6 targeted classifications would respond directly to the problems we've encountered. First, foreseeability. Relevant entities and means should be bound by evidence of a concrete identification pathway, rather than an ever-expanding cast of hypothetical attackers. Failure of one technical test should trigger further contextual analysis, not automatically determine legal status. Second, contracts. The board should define the evidential weight of enforceable restrictions, audit rights, monitoring, and remedies when they form part of an audited technical and organizational control stack. A promise alone must never manufacture anonymity. Third, processors. The anti-evasion principle should remain. A controller cannot outsource its way out of the GDPR, but the guidance should calibrate the obligations and practical consequences for processors that are genuinely unable to identify you. Fourth, separability. One personal component should not automatically contaminate every separable non-personal component of a mixed dataset. Equally, an anonymous component cannot cleanse personal data surrounding it. Fifth, testing. Organizations need recognized and proportionate means for no record isolation, no linkage, and no inference, including methods appropriate to free text, synthetic data, and models. Reusable approaches are particularly important for smaller organizations. Sixth, review triggers. Reassessment should follow material changes in recipients, auxiliary information, technology, purpose, or security. It should not become an indefinite obligation to prove a negative. The EDPB has opened this doctrinal bridge. These 6 clarifications will make it clear enough, narrow enough, and affordable enough to cross without lowering the legal threshold. Once that bridge becomes workable, however, the larger question becomes unavoidable. What kinds of non-personal data lie on the other side? That larger question is the subject of my 5th post on the anonymization guidelines in my Law Boy series. We need to distinguish 4 ideas that EU data law too often collapses into a single residual category. Anonymous information describes the legal state. No person is identifiable from the perspective of the relevant actor. Anonymized data describes provenance and process. The information began as personal data and was transformed until it reached that anonymous state. The processing that produced remained governed by the GDPR. Synthetic data describes a method of generation, not a legal conclusion. Its output may be anonymous, but it may also memorize, reproduce, or permit inferences about individuals. Other non-personal data include industrial, environmental, machine-generated, and genuinely aggregate information that may never have related to an identifiable person. These categories create different questions of assurance, utility, governance. Leaving the GDPR does not mean leaving law. The DMA, Data Act, competition law, trade secrets, intellectual property, cybersecurity, contractual governance may all remain relevant. The 3 books shown here approach that wider research program through data protection, deceptive design, AI, and neurodata. I continue the argument through my Law Boy Substack page, Digidata Consulting, and my work at the Riga Graduate School of Law. The final question is therefore not simply where information once touched a person. It is what this information permits this actor to do in this environment using means reasonably likely to be used and what governance should follow. This is the road from SRB to a usable law of non-personal data. Thank you.